Hey folks, James Abrinio coming to you from Abrinio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I wanted to address an issue that comes up a lot. James, what should I expect in my Virginia car accident jury trial? Now, if you're watching this video, I want to make clear this video is not meant to give you every single detail about how jury trials work here in Virginia when it comes to car accident cases. You're not going to be prepared to try your own case. Rather, this video is really meant to give you kind of a 1,000-foot view to give you better context on what to expect. If you're represented by my firm, we will go in a lot more detail as we prepare for trial. If you're watching this video and let's say you've got your own accident case, you're trying to figure out what you should be doing next, hopefully this gives you a snapshot of the end game about what may happen. It gives you better information so you can make better decisions. Even if you're represented by counsel and you're just looking for a better sense of what's going on, hopefully this video will be useful in guiding you through what you should expect. So when we're talking about jury trials, a couple things to think about. Now, this is really as we get very basic questions that I receive. The next question I usually get is, how long should I expect my jury trial to take? And I will tell you, this is very fact specific. It'll depend on the complexity of your case. It'll depend on how many witnesses you have, how many pieces of evidence you expect, how complicated your witnesses will be. So let's say you suffered a significant brain injury, and we're going to have multiple medical doctors and neuropsychologists come in, and we're going to have a lot of complex evidence and dry evidence in a lot of ways. Well, that's going to take longer than if you have a simple back injury case where you got some physical therapy, of course. So it can really depend on each case. Now, when we're talking about jury trials, the members of your jury are going to be 7 jurors of your local community, 7 members of your local community. There's very foundational rules in order to qualify as a juror. You've got to live in the jurisdiction. You've got to have no felony conviction. You've got to be a citizen. And there's a few other basic rules that you have to meet the threshold to comply to be a juror. But beyond that, though, the world is your oyster. There are going to be a lot of representatives in your community, whether it's educated, the uneducated, everything in between. There's going to be rich, there's going to be poor, there's going to be black, there's going to be white, and there's going to be gay, straight, and everything. And really, the point of the jury in an ideal world is to get a broad spectrum, so we get a broad representation of your community, and hopefully one that is tailored to your case. Now, that being said, it's really a luck of the draw a lot of ways. Sometimes you have individuals more representative of one community versus the other, one socioeconomic status versus the other. And so it can be a very weighted specific jury, or it can be a very broad one. But from a threshold standpoint, it is pretty basic to be able to qualify as a juror here in Virginia. Now, one aspect that you also should be aware of, and a lot of people have questions about this, juries don't get to learn about insurance in Virginia car accident cases. That's insurance whether it relates to auto, car insurance. That's insurance whether it relates to health insurance or any other type of insurance. In fact, it's a well-known rule amongst lawyers in the trial community that you don't say the word insurance. And if somebody brings up the word insurance, you do your best to avoid that topic. Juries in a perfect world are not allowed to consider the presence or absence of insurance. So if you're claiming for $100,000 of medical bills, in theory, juries are not supposed to be asking, well, did health insurance pay those bills, or are they still outstanding? They're not supposed to be asking, well, is the defendant in this case going to be actually paying that judgment, that amount that we award, or is it going to be the car insurance? They are not supposed to be asking those questions. Now, in practice, does that happen? I think anybody that's dealt with juries as trial attorneys realize that things that are not supposed to happen actually happen. But by Virginia law, they are not supposed to be considering presence or absence of juries. And The reality is juries do get things wrong. Juries do compromise. Look, if you're looking at having a jury trial in your case, if you've decided, you know what, it is my best interest to go before a jury to ask 7 members of my community to fairly award me for my case, you've got to realize that once you step into that arena, so to speak, all bets are off. Now, your attorney, if it's me or whoever is going to be representing you, is going to be doing the best they can to fight for the fairest trial possible in your case. But at the end of the day, once the case goes back to the jury, there's only limited things that we can do in order to police that in a lot of ways. And a lot of times I've had cases where I will ask juries after a case why they came up with the decision they came up with, because it was surprising to me. In many instances, I found that, let's say 6 jurors wanted to award the amount that I thought was fair. 1 juror wanted to award very little amount, and in order to compromise, they reached somewhere in between. I've spoken to jurors that are clearly considering evidence that was not supposed to be considered, and all that. So you just have to recognize that it is not a perfect system. There are human beings involved, and while we do our best to preserve the integrity of jury trial, and in your case, once it goes back to the jury, there's a lot of things that you should expect to happen that they're going to happen. And what is the recourse? Unless there's a significant flaw, a significant error, a lot of the times the recourse is it is what it is, because it doesn't make a whole lot of sense from a financial standpoint to undo that. But obviously, if you have concern after your jury trial, you're going to be asking your jurors to see if you can understand better what's going on and investigate that from there. But juries do get things wrong. Juries do compromise. That being said, I also want to be clear. Well, some people say, well, why don't we just have a judge try our case? All in all, if I have to choose between a judge and a jury for a car accident case here in Virginia, unless there's something unusual about the case, I typically want a jury. I typically trust juries more. And look, I have a lot of friends who are now judges. I'm getting to that point in my career, and I think they're very smart folks. But at the end of the day, I trust juries over judges, because first of all, you're never sure which judge you're going to get, and also I don't want just one person having to decide or getting to decide what the outcome is. I'd rather have 7 folks making that decision. So that's my viewpoint. Now, once you've decided to go to the jury, you're going to court, you're in court, the first thing that's going to happen is what we call jury selection, or what we call voir dire. That's when each side gets an opportunity to ask potential jurors about their proclivities, about their biases, about how they may or may not view the world and how it relates to your case. Typically speaking, the plaintiff side. So if I'm representing you, I will go first, and I will be the one to start off voir dire or jury selection. And from a style point of view, I will tell you, I don't simply start off by just asking jurors questions. A lot of times I use jury selection as an opportunity to get to know the jury, to try to build some rapport with the jury. I will try to throw in a few jokes here and there, but not overdo it. But when I'm asking jurors questions, a lot of the times my goal is not necessarily just to identify folks that might be biased for or against you, but also try to get them interacting with them and also interacting with me, so I can get a better sense of how they're feeling towards myself, towards my client. Again, juries aren't perfect. So in a lot of ways, fair or not, a lot of times juries can be swayed by who's likable. So I tend to think that my style is a bit more likable in a lot of ways than you'll get from the average insurance adjuster, attorney, insurance defense attorney. I try to do my best to relate with jurors. I like talking to jurors. I will smile with them. We'll make jokes together, things like that. But all in all, I'm still trying to get that much needed data to figure out whether or not a particular juror is going to be good for our case or bad for our case. Now, a lot of our questions, both sides are going to be talking about biases. So for instance, a few examples, do you believe that there's a need for tort reform? So if I'm a plaintiff's attorney, I'm representing my injured party. There's a thing called tort reform that insurance lobbyists have done a good job on, essentially convincing a large section of the public that lawsuits are all invalid and frivolous, and that we need to reform the system because injured parties are unfairly receiving windfalls through the trial process. So they've gone out of their way to try to convince many prospective jurors just through the media that anybody that's suing is an ambulance chaser, that all attorneys or plaintiffs' attorneys are unfair and they're just trying to milk the system. So a lot of times I will be asking people straight up. The way that I do things is I ask very direct questions. In fact, I've been known to ask, does anybody here know what the term ambulance chaser is? And as soon as I see people smiling and raising their hands, I have them explain it to me. And then I say, look, do you believe that just because I'm an attorney representing an injured party, that's unfair, that I'm trying to milk the system? Do you believe that because my victim, my injured party, is claiming injuries, that they're just trying to milk the system? The other example is, do you automatically believe if law enforcement is involved, are they going to have more credibility than just the average Joe? For instance, if I have a law enforcement officer that may not be helpful in our case, those kinds of questions. Other questions would be, have you ever had serious medical treatment? Have you ever been sued before? Have you ever had situations involving lawsuits that may affect your ability to be fair in the system? Are you related to anybody that is an attorney that may have a bias towards or against plaintiffs' attorneys? So we're trying to do our best to understand potential jury biases. But again, just to be clear, it is not perfect and jurors lie. I can't tell you how many times that I've spoken to potential jurors or actual jury members after a verdict, when after I've spoken to them, it was clear to me that they weren't being fully truthful when I was asking them questions in jury selection. And it come clear as soon as I found out their reasoning behind their opinions. And again, the jury, there is no perfect jury. At the end of questions, each side gets a chance to strike potential jurors for cause, meaning they're either biased or other unfair reasons. And then after that, each side gets a certain amount of juries. They just get to strike for whatever reason. And a lot of times the reasons will be, well, that person said something that kind of irked me about their views on tort reform, or that person said something about this or that. Sometimes it'll be, look, the whole time as I'm giving an opening, my jury selection, and I'm asking questions, that juror is scowling at me and they're not laughing at my jokes. They're clearly not happy with me. They don't like me, or they're scowling at my client. And so you do your best to try to knock off the jurors that are going to hurt your case, that are going to find against you. And I can tell you the insurance defense attorney on the other side is going to be doing the exact same thing, except they're going to be trying to do things that are picking jurors that hurt your case, that are good for them. So that's jury selection, kind of a 1,000-foot view. Now, the next thing that's going to happen is what we call opening statements. What is an opening statement? Both sides get an opportunity to tell the jury what they think the case is going to be about. And this is what I think the evidence is going to show. These are the witnesses we think that you're going to hear from. These are what the expert witnesses we believe are going to opine. This is how we believe the evidence is going to show that my client was not at fault at all. And this is the reason we believe that they were hurt. And these are the damages and injuries you should expect. So we are going to outline our case on the plaintiff side, and the defense is going to do the same. And so both sides get an opportunity to outline their case. Now, to be clear, opening statements are indeed important because it gives the jury context to know where we're going with this. However, it is not evidence. So I can make the greatest opening statement in the world, but at the end of the day, if a jury is doing its job right, while my opening should help them kind of understand what they should expect, at the end of the day, the evidence is the witness and the exhibits, not my opening statement. For me, my goal with opening statements is, number one, is to connect with the jury so they believe that I'm credible, that I'm building rapport with them, because if we've lost credibility, if we've lost it all. But number two, again, is to give the jury the ability to know what to expect. I think humans are able to learn better, and that's the goal of a trial, is to educate the jury as to why they should find for you. But I think that juries and I think individuals learn better if they have a context of what to expect. That way, information is not just being thrown at them without any context whatsoever. So my goal is to build rapport with that jury. And number two is to educate that jury. Now, when it comes to evidence, so let's assume the opening statements are done. Now we're going to actually presenting evidence. We are the plaintiff, so our burden is to prove more likely than not each element of our case. So we have the burden, therefore we go first. And again, just to reiterate, we bear the burden here, and so we do go first. Now, what is our evidence? It's going to be our witnesses, number one, and this is going to include the plaintiff, the injured party, any corroborating evidence, any medical evidence, and any other evidence that's going to help establish liabilities or injuries, whether it's related to actually witness the accident or related to corroborating injuries. And so we're going to put up our evidence, and then the defense gets a chance to cross-examine our evidence. So if the plaintiff testifies, the defense attorney then gets a chance to cross-examine the plaintiff. If my neurologist then testifies about the brain injury and the treatment and the medical bills, the defense then gets an opportunity to cross-examine that witness. So anytime I put up a witness, the defense gets a chance, an opportunity to cross-examine that witness. If I introduce an exhibit through that witness or an exhibit in general, the defense can cross-examine that witness on that exhibit or other witnesses on that exhibit. So they get a chance to test our evidence. Just because we say things doesn't mean it automatically is believed. Now, again, what is our witness and evidence? Plaintiffs, supporting witnesses, expert witnesses, any other witnesses. And again, exhibits are introduced through witnesses typically. Sometimes the parties will have stipulations as to what evidence comes in. So we all stipulate that these photographs are true and accurate, and they are the accident scene and the damages. These medical bills are true and accurate, and we're stipulating that these are incurred because of the accident. But typically speaking, we'll have witnesses describe and introduce the exhibits. Now, once the plaintiff finishes their evidence, the defense will have a chance to do what we call a motion to strike. And for many cases, it may not matter because we've essentially met our burden to where we can go forward to where a judge isn't just going to say is what we call as a matter of law, the plaintiff loses. It's going to be very unusual to lose in a motion to strike. But if there's concerns about motions to strike, so for instance, let's say we've sued two parties and we've established that one party is at fault, but we haven't established the second party is at fault as well, then they'll move to strike that second party and that may lose. Now, if you're working with an attorney, your attorney should do a decent job of giving you a heads up about expecting the motions to strike so they're not a complete surprise. But that being said, sometimes surprises happen at trial, and motions to strike are granted even though they weren't anticipated. But again, this video is really just giving you an outline of that. Now, once the plaintiffs goes, motion strike's done, the defense then gets the chance to put on their evidence. And it's going to mirror in a lot of ways the plaintiff's evidence. Their witnesses are going to go up, their exhibits are going to get introduced, and then we get a chance to cross-examine their witnesses. We get a chance to cross-examine their evidence. So if we put up our neurologist, they're going to put up their own neurologist, and then I'll get a chance to cross-examine their neurologist about their opinion. Let's say the defendant says the accident happened one way, whereas the plaintiff testified another way, and they were cross-examined. I will get a chance to cross-examine them as well. So once that happens, if there's new issues raised, the plaintiff then has an opportunity to introduce rebuttal evidence. So if there's something that comes in through their evidence, we then have an opportunity to produce more evidence. And in the same manner, we will put up those witnesses and exhibits, and then they'll get a chance to cross-examine that. I'm not going to get too much into what rebuttal evidence in a particular case because it really depends on every case, but it'll be very fact-specific. Now, the next issue will be once the evidence is in, jury instructions. What are jury instructions? Jury instructions is where the judge outlines the laws of the case. So they'll provide foundational definitions like what is contributory negligence, what is circumstantial evidence, what is the preponderance of the evidence. And so they'll outline basic rules of the law. Again, burden of proof elements. So you have to prove that in a car accident case that the defendant had a duty of not committing negligence against you, that they committed that negligence, and that negligence was the cause of your injuries and it was a proximate cause of your injuries. So those are going to lay out the elements for the jury to understand. They're also going to talk about how to award damages. So your injuries, So in a car accident case, they're allowed to, the jury's allowed to award you medical bills, pain, suffering, inconvenience, lost wages, future bills and lost wages, and any other evidence. So the jury instruction is literally going to lay that definition out there for you, and any other unique issues that come up at trial. A lot of times, I, as a plaintiff's attorney, will ask for unique jury instructions based on the trial. Again, I'm not going to get into the details of that because it's really fact specific on the case. And then after the jury jury instructions are selected, because essentially the parties will argue over the jury instructions, and then the judge will grant whatever jury instructions are appropriate. The judge will then read the jury instructions, and then the closing statements will happen. And just like before, each side will summarize what they think the evidence is that showed it. Again, it's really putting a bookend to your case. So whereas the opening was to tell the jury what they should expect, the closing now is the attorneys outlining what the jury's just heard. So what they're going to do is they can focus on important jury instructions that were just granted. They can point to important pieces of evidence. They're going to highlight the good aspects of their side of the case, and they're going to point out the weaknesses of the other side of the case. And really, that's an opportunity, again, for the attorney to really do their job, again, building rapport and finalizing that rapport with the jury before they go back with the case, but also really highlighting why they think they should win and summarizing that evidence for the jury. Now, for the more complex cases, I think closings are way more important, because if you have several days of evidence, sometimes several weeks of evidence, there's a lot for a jury to sort through. So it's your job to advocate. As me, the attorney, it's my job to advocate for my client as to what I think the jury should really be focusing on, and why they should not listen about the other side. And it's really my opportunity to really give my final piece for the jury. Now, once closing statements are done, the case is now going to go back with the jury, and we're going to be waiting for a jury verdict. A jury verdict is when the jury essentially awards, they decide the case. Number one, was the defendant liable for the injuries? And if so, how much should they be awarding? How long it takes to get to a jury verdict, it can really depend on every case. I've had cases where a verdict comes in 30 minutes. I've had a case where it took multiple days for a jury to come back for an answer. And why that is, it really depends on the complexity of the case. Again, depends on the makeup of the people and everything in between. So it can be really complicated. But I will tell you, all in all, if you end up having to try your case in front of a jury, I like the process. I think it's an opportunity for our system to really shine. And again, while I've highlighted a lot of the imperfections of the jury system, in a lot of ways, number one, I would prefer it over just a judge deciding. But number two, I would prefer it over taking a bad offer from an insurance company. If you think your case is worth X and the insurance company's offering Y, which is presumably lower than X, you have an option, and that's to exercise your right to trial. And in my view, I would rather have a jury give me a low number that I'm not happy with, rather than accepting a settlement for an insurance company from an insurance company for a number I'm not happy with. Now, that being said, I will say, look, jury trials are stressful. They're not fun, at least for the client, typically speaking, unless, it's just everything's going well. But usually, typically speaking, they're very stressful events. They take a lot of time and emotional cost. And they cost a lot of money, because you got to pay for doctors, you got to pay for experts, you got to pay for other things. And a lot of times that may cut out of your bottom line. So many instances, even where I'm recommending a jury trial, clients may not want to go forward because they don't want to deal with the stress and the financial cost of it. And they're happy enough with the number being offered. And for a lot of people, there is value in certainty. They'd rather know the number they're getting rather than trust a jury. And I totally get that. At the end of the day, if you are injured in a case, it is ultimately your decision whether or not to accept a settlement. It is your decision whether or not to go to a jury trial. So it should not be me, the attorney, telling you what you need to do. It is my job to educate you as to what I think the law is, what I think a good process is, what I think a good offer is, and then educate you, just like I'm doing here, about the process itself. But ultimately, it is going to be your decision to make. So I don't want to be in a position, and nobody should be in a position where they tell you either have to go to trial or you have to settle your case. I think the goal should be for your attorneys to make sure that everybody's prepared to make the decision that is right for your case, and ultimately you to make the best decision for your case. So look, hopefully this was useful. Wish you guys the best. Here's my information again. If you have questions about your Virginia car accident case, feel free to reach out to us. Phone number 703-570-4180. Here's my email. Here's our social media. If you found this useful, make sure to click a like button here and go ahead and subscribe to our YouTube channel. We're trying to provide a lot of information. Wish you guys the best. Until next time, take care.